Hi, I'm Mark Reinhardt, partner and attorney with Rehberg Law Group. For half a century, Rehberg Law Group has helped thousands of people set up their estate plans and help the next generation carry out those plans with a minimum of fuss, costs, and bother. Our goal is to exceed our clients' expectations by unsurpassed expertise, compassion, and advice in all areas of our practice. First, thank you for taking the time to watch this video. Give yourself a little pat on the back for taking the time to learn a little bit more about estate planning. There are a lot of myths, misunderstandings, and mistakes that can frustrate even the best intentions. Learning more about the tools and techniques of estate planning can help you and your attorney avoid mistakes and make better decisions. In this video, I'm going to cover some of the basic documents. Think of them as the tools of estate planning. These include wills and trusts and some fundamental differences between them, powers of attorney, and directives to physicians. Now, this video won't cover everything, of course. Other documents may be helpful or even necessary. That's what a meeting with your attorney is for. But a little time and effort now can save a lot of time and effort later. It may even save having to make additional meetings, and they often lead to additional cost. Now, you already may know this, but estate planning can be a little intimidating. First, you have to think about your own or a loved one's death, and for most of us, that's no fun at all. But there's no avoiding it. As Ben Franklin said, nothing is certain but death and taxes. And good estate planning addresses both. Still with me? You haven't turned off the video. Nice work. Then let's turn to the second problem that many people have with estate planning, the jargon. It's easy to get confused by wills, living trusts, revocable living trusts, living wills. Help! Have no fear. This video will begin the process of helping you understand some of the key tools of estate planning. Let's start with wills. Now, most of us understand what a will does. It basically says three things. First, who's in charge? This is your executor, the person who will handle your estate after you die. If you have minor children, it should also name who your preferred guardian is for them. Second, your will says where things go. This may be pretty simple, such as all to spouse, but if they're gone, to children in equal shares. Of course, it could and often should be a bit more sophisticated than that. And third, your will says how things go. Either you can give things directly to people, or if there are concerns, perhaps keeping it in a testamentary trust for them. Is a child struggling financially? Is a grandchild or child disabled? These answers help determine how to structure your gift for your loved ones. Don't worry about figuring out all of this right now in this video. Your attorney will help walk you through all of this in your meeting. The good news about a will is that it helps avoid a mess. It tells you what you want, who's in charge, where things go, how it goes to people, and you're basically done when you sign your will. And a will plan usually costs a bit less than a living trust plan. However, there are potential weaknesses with a will that you'll want to think about. Some people are concerned about them and others aren't. The first potential weakness is that a will is dormant during your life. In other words, it springs to life when you die. If you enter into a long-term incapacity, Alzheimer's or dementia perhaps, your will does not help you. You will have to depend on your powers of attorney, which we'll talk about in a few minutes. The second potential weakness of a will plan is that because a will does not change title to things while you are living, that is, your name stays on your accounts and your home, your executor will probably have to do something called a probate to get control of your assets after you die. And probate is a court process designed to obtain proof from a court. These are called letters testamentary, that your executor has authority to get control of your accounts and properties so they can carry out your wishes. In brief, getting those letters testamentary through a probate leads to time, cost, and effort. Your attorney can talk with you in more detail about how long, how hard, and how much a probate might cost in your situation. Of course, since using a will generally does mean there will be a probate, it is a bit easier to contest and becomes a public document through the probate court process. Another option or tool that you can use for your estate planning is called a living trust. These are often called revocable living trusts. Same thing. What this means is that while you are living and have capacity, you can change, amend, or revoke your trust. You are in charge of your assets and your finances just like you are now. After you create your living trust, the next step is to fund it. Funding means changing the title to or the beneficiaries of your assets so that almost everything that you have is in your trust or passes by beneficiary designation. The end result is that because you have little or nothing in your name when you die, probate isn't needed. Since you did the work, that is, you put together a trust and you funded the trust while you were alive, most of the work involved in administering your estate after you die has already been done. There will be some things that your successor trustee will need to handle, but the vast majority of the work has been completed by you. That means less time, less effort, and less money after you die for your loved ones to take care of things. And since there's no public probate process, that means that your estate administration is going to be harder to challenge and there is a lot more privacy. Living trusts are like a will in some ways, but they're different in other ways. Like a will, a trust controls what happens after you die, stating who's in charge, called the trustee, where things go, and how. However, unlike a will, a trust also handles assets during your life. A living trust, therefore, offers incapacity protection because it addresses who might manage your trust accounts if you become incapacitated. So, what's the problem? Why doesn't everybody get a living trust? Well, a living trust is probably going to cost more than a will plan for you, at least while you're alive. It is a more complete document and it'll need to be funded. That is, assets need to be retitled or a beneficiary designation needs to be carefully crafted. Now, we'll partner with our clients to help fund that trust. Remember, funding, the process of retitling assets, and adding beneficiary designations. However, because you've done all that work now while you're alive, your executor, the people in charge after you're gone, won't have as much to do, not nearly as much to do after you're gone. So, okay, Mark, you ask, which should I get? That's a question that you and your attorney will work together to answer. Many choose wills for simplicity and cost. Others choose living trusts because they're concerned about incapacity protection or they want to make sure that their estate avoids probate. You have to decide with your attorney's help what is more important to you. So that's wills and living trusts, but there are other documents that will be needed as well. A durable power of attorney is the first of those. That's a document that empowers someone else, your agent, and gives them the authority to access your information and accounts so that if they need to help you pay your bills or manage your finances, take care of your legal matters, or even pay your taxes on your behalf, if you can't, they can do it for you. You'll want to have at least one primary agent and one backup, just in case something happens to the first person that you name. If you're married, that first person is typically your spouse, but then others will come after them. Now, many times I'm asked, Mark, why is this called a durable power of attorney? Why durable? Because it endures. It still works even if you become incapacitated. The next document would be your healthcare power of attorney. In this document, you authorize someone else to make healthcare decisions for you if you're unable to make them for yourself. This should be a separate document from your durable power of attorney, not least because you may choose different people to act in different ways. Some are better with healthcare, some may be better with making financial decisions. Again, having a primary and a backup is going to be really important, just in case. The third document that we want to make sure you have, in addition to the living trust and the will, would be a directive to physicians. Now, it's very confusing. This is often called a living will. Since we've already talked about a living trust and wills, that's pretty much guaranteed to cause confusion. So let's stick with directive to physicians for this document. It's a end-of-life document. It's designed to work under certain end-of-life conditions. It directs a hospital or a doctor, if they're reluctant to withdraw or withhold treatment without your authorization, it will tell them what you would like to do. Now, this comes as a surprise. Without a directive, that doctor or hospital may not choose to honor your spouse's or your family's wishes. So a directive to physicians spells out in advance what you would like to have happen under those end-of-life trigger conditions. Death is imminent, no real hope, or you're brain dead, permanent unconscious, no real hope. It can tell the doctors and your agent whether or not you'd like to have artificial hydration and nutrition, whether or not you'd like to have heroic measures, and in any of those cases, for how long. Or you may simply say, I don't want heroic measures, I don't want artificial hydration, I don't want artificial nutrition. If there really is no hope, make me comfortable, give me the drugs, give me palliative care, but otherwise let me go. Then they are more than likely, the doctors, the hospitals, to honor your wishes. Okay, now we've talked about a lot of documents in a short video, right? Living trusts, wills, powers of attorney, and directives to physicians. But don't worry, you'll have a longer meeting with your attorney to explain these things in more detail in your meeting. For now, you really only need to have a general sense of the estate planning tools and understand that each has its own part to play in creating an estate plan that works to give you peace of mind, control, and value. In your meeting, your attorney will help to avoid jargon and legalese and help you try to understand these tools and make good decisions about your plan. The basic estate planning concepts and considerations and documents will all be explained. Relating them to your situation, your goals, your concerns, a plan can be developed. The meeting is without obligation. At the end of the meeting, your attorney will give you a fee quote, and based on the documents you'd like us to prepare and the complexity of what you're asking us to do. You can then decide whether you want to move forward on things or you need time to think about it. But remember that unless you act on the information, unless you have documents that are done, completed, and properly executed, none of this is going to help at all. Thank you so much for your attention. We look forward to meeting with you soon.